Hey, I'm individual disability and ERISA disability attorney Nancy Cavey, and I want to welcome you to this episode of Winning Isn't Easy. Before we get started, I have to give you a legal disclaimer. The Florida Bar Association says I have to tell you that this podcast isn't legal advice. So now that I've said it, nothing will prevent me from giving you an easy to understand overview of the disability insurance world, the games the disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Have you received a denial or termination letter from your ERISA disability carrier? You probably were shocked. And as you read it, you thought, are we talking about the same claim, same case? Because a lot of this doesn't sound familiar. In fact, it looks to me that they may have even cherry-picked my medical records, misconstrued what my doctor has to say, and are calling me a liar because they don't think I'm credible. And they've made up all of these reasons to deny or terminate my benefits. Well, there are some protections under the ERISA regulations that will help you overcome potentially an improper claim denial or termination if they violate ERISA rules or regulations. So I want to talk about 6 different things today about mistakes and problems caused by an improper violating ERISA disability regulation denial or termination letter. And the importance of this is that ultimately we can use some of these mistakes potentially to overcome that wrongful denial or termination. So the first thing I'm going to talk about is what are the disclosures that an ERISA disability carrier plan has to make in the denial or termination of benefit letter? Secondly, what are the common mistakes that they make in that denial or termination of benefits letter? Thirdly, what mistakes are made regarding the description of additional material or information the carrier plan thinks is necessary to perfect your claim? Fourth, are there more mistakes that disability carriers or plans make when they deny or terminate disability benefits? 5, why an ERISA disability carrier plan's explanation of any medical, scientific, or clinical judgment they used applies to your medical condition and your claim is often bull and what you need to do about it. And lastly, how using the carriers or plans specific internal rules, guidelines, protocols, standards, or other similar criteria can be used to overcome your claims denial. Got it? We've got a lot to talk about today, but before we do that, let's take a break for a moment, okay? Welcome back to Winning Isn't Easy. Now, we're going to talk about what disclosures must an ERISA disability carrier or plan make in a denial or termination of benefits letter. Have you gotten that denial or termination letter? You read it cover to cover. You don't understand what's going on. It's as clear as mud, and you, with good reason, are as mad as a wet hen. Did you know that most disability insurance policies or plans are governed by a federal law called ERISA, the Employee Retirement Income Security Act? Regulations have been enacted under this statute that are designed to protect you, the policyholder or plan beneficiary. These ERISA rules or regulations include a full and fair review requirement. That includes disclosure requirements to promote a meaningful dialogue between you and the disability carrier and plan about why your claim was denied or benefits were terminated and what you need to submit as part of the appeal. Now, under the ERISA statute, you have 180 days in which to file an appeal. That is the trial of your case, and you have to exhaust these administrative remedies before you can file a lawsuit. No new evidence is going to be allowed in front of a judge once the appeal process is completed. So that's why this appeal really is the trial of your case. That in turn makes it really crucial that the disclosure regulations are followed so that you in fact understand why they did what they did, how they did what they did, what you need to do to submit evidence to them in a manner that they want so that you can overcome this claims denial or termination. These disclosure regulations are really crucial to the full and fair review because otherwise they're going to hide the ball and move the goalpost in the appeals process. So what information are you required to be given in the denial or termination letter? There's a laundry list. First, the specific reasons for the denial or the termination. 2, reference to the specific policy terms or plan terms that are the foundation of the denial or termination. 3, a description of what additional material and information the carrier or plan thinks that is necessary to perfect your claim. An explanation of why the additional material and information is needed. Next, a description of the plan or policy review process. And next, an explanation of why the carrier or the plan disagreed or did not follow the opinions of your physicians or the opinions of even their own liar-for-hire doctors. They also have to explain why they did accept their liar-for-hire physician's opinions over that of your doctor. They have to explain the opinions of the vocational evaluator that they used. They have to consider the opinions of and the decision of the Social Security Administration. They have to provide an explanation if the determination is based on medical, scientific, or clinical judgment, how that applies to the terms of your policy or plan. They have to disclose and discuss the specific internal rules, guidelines, protocols, standards, or other criteria that they relied on in denying or terminating your benefits. And they have to tell you that you're entitled, upon request, to get a free copy of all the documents, records, or other information relevant to your claim for disability benefits. They also have to tell you the time frame that you have in which to submit an appeal and the time frame in which they have to respond. And they have to tell you about your right to file a lawsuit and the time frame by which the lawsuit must be filed. Now, I'm often asked, do these full and fair review disclosure requirements really work? I will tell you that these new regulations are an improvement on the old regulations, but carriers will still hide the ball, and in my view, they fail to clearly explain why they denied or terminated benefits. Look, we know that they don't want to pay, and they know that we know they don't want to pay, and they'll use the regulations to muddy the waters and hope you just give up and go away. But that's not how I operate. I'm a little bulldog. I'm not going to give up, and you shouldn't give up either. You really do want to get a copy of the claims file and start your review, or better yet, have your lawyer get that claims file and start the review to determine first and foremost, did they meet the actual disclosure requirements of the ERISA rules and regulations? Got it? Let's take a break.
Robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.